may be seated.
2 objections.
Okay.
2 exhibits.
What do I need to come down and see something?
No, I'll just hold it up for you. This is excerpts from a deposition. It's not an evidence, so I object to it.
I will say that these excerpts were read into the record in testimony, and I can qualify them by saying such, Your Honor.
This is actually, there's also a page here that's not an evidence, so I do object. Counsel can argue it, but this is actually a page for deposition. It's not an evidence, so.
I would just ask for some type of instruction that the exhibits are for demonstrative purposes only, and they should rely on their own recollection of the evidence.
But
In fact, I would even be more than happy to say so.
it has portions that are not discussed at all.
I don't
See what I'm saying?
even think they could read
Just a
that.
second.
Yes, sir. I'm sorry.
One at a time, Mr. Ashton.
I mean, I can read it. So can, I think anyone else would. My eyesight's not that great, but counsel can argue it. It's just, it doesn't, this elevates it to a level above just a question being asked. This is an actual part of the deposition itself.
You don't have you don't have any problem with the excerpts, do you?
Well, yeah, I do, for the same reason I have a problem with the other quotations, because clearly this isn't clearly this is not counsel's memory of what was said. This is an actual photograph of the deposition itself. So, I mean, the other ones we can say, well, he can say, well, this is my memory of what they said, but clearly this is the actual deposition itself. And if counsel necessarily didn't say it that way, it wouldn't be the same. So they have to rely on what he said, not what the devil said.
I don't think the standard is someone's memory. If I wanted to write down exactly word for word what a witness said on the witness stand, I could do so and regurgitate that in argument. This is argument to the jury. This was actually admitted in trial and testified about, and that's what I would like to do. I, of course, agree that it should be noted that they should rely on their own recollection as to what I'm telling them. Same for Mr. Ashton. He made numerous statements that I, of
Okay.
course, disagree.
Anything else, folks?
Nothing further.
What I will do is the portion of the page, Mr. Ashton is exactly right. Put some white paper on that. Yeah.
I don't want to take these out of order. If the court can see this right here is it's sideways.
Oops.
There, the photograph in the middle is not one that's been introduced into evidence. It shouldn't be used in any way, shape, or form during the argument. Certainly, as argued as it relates to the previous exhibit, counsel can make reference to what he apparently is going to term imaginary friends.
Who's the
However,
photograph in the middle?
well, we don't know, but we can assume from the looks of it that
Looks
it's
like
a
Miss Anthony at some
young-
stage. Well,
Right.
probably wasn't the best photograph to choose, but how is the state prejudiced?
Well, because it makes her look young and that it's some sort of childlike invention that she has come up with these individuals as opposed to a picture of her at age 22. One of the photographs of Ms. Anthony that was objected to was a smiling photograph taken at the Orange County Sheriff's Office because it had no relevance to the case. If they want to substitute that photograph of a smiling Casey Anthony on July 15th or 16th of 2008, that might be more appropriate than having a picture of a child with an argument that her lying is childlike and that she creates these individuals. It's not even a comment on the evidence because I'm going to guess she's in 8th grade in that picture.
What is the date of the photograph, folks?
I don't have the exact date of the photograph, Judge, but it is Miss Anthony is a young woman.
That doesn't answer my question. How old is she in the photograph? What is the date of the photograph?
Find out and see if I can get the approximate date.
The other representations obviously aren't accurate either, even though they're caricatures. There's no testimony about Eric Baker, as I recall.
There was. Again, Judge, this is our case. This is
I just need to know when the photograph was taken, folks.
Was taken.
It's a school picture. Somebody knows what grade it is.
Miss Anthony, if Mrs. Anthony can take a look.
It's like 11th grade.
No. I'm sure she's wearing makeup in high school.
Is it a school picture or is it when she was age 22? If it was age 22, then fine. But if
Can Mrs. Anthony come forward and you can take
just take it back there to her.
2001,
Yeah, I
Judge.
got here.
10 years ago?
Yeah, I had them take that out.
It was 2001. The events happened 2008. And I won't be making, it's just a photograph of Miss Anthony. And I would note that these imaginary friends were testified that they were at least 2 years in existence.
I don't care about the imaginary friends, but what troubles me is you got a photograph from 2001 as opposed to something at age 22 or even 21. But how old was she in 2001?
I would say 17, something along those lines.
Nah.
16, 17, I have no idea.
Well,
Probably 14 or 15.
I don't think she's 14.
well, I don't care about the imaginary friends, but that there just distorts reality.
May we have a moment to replace it with another photograph?
You may. Anything else? Okay. He had a book of photographs, other things I think that he was going to have through a PowerPoint. Have y'all had a chance to look at those? The one that I came up and looked at that he flipped through?
Posters, Judge.
Okay.
At least that's what was represented to us at these posters.
That's it. We're not showing any other.
Okay. And the one thing that we did agree was that for some of the printed matter in there that there are his statements.
Statement of his
Okay.
recollection, not-
Right.
Not quotations. Yes, sir.
Okay, just a reminder to everyone, once we start giving the jury the final instructions, no one will be permitted to leave or enter. So if you don't want to stay during the entire time, you will have an opportunity to leave. But once I start reading the charge to the jury, no one will be permitted to leave or enter or move or about. Does the state recognize the presence of the jury? And does the defense?
Yes, sir, we do.
You may proceed, Mr. Baez.
Thank you, Your Honor. May it please the court, my colleagues in the prosecution. Good morning, ladies and gentlemen. I, too, would like to thank you on behalf of the defense for the sacrifices you have made as citizens of the state of Florida. We know that it came at a great sacrifice, and both sides saw how much attention you paid to the presentation of evidence in this case. And it hasn't gone lost on us. We all have recognized that. And I want to thank you both individually and collectively for that great sacrifice that you've all made. Thank you. Here we are at the end of our journey. And I have to tell you that I probably think you have more questions than you have answers. And if you recall at opening statements, the final thing that I told you at the end of the day, when everything is said and done, the one question will never be answered. The key question in this case will never be answered. It can never be proven. And that is, how did Caylee die? That's why we're all here. Really. There's no dispute that Caylee is passed on. There's no dispute whatsoever about that. So really, the key question, as it relates to all manslaughter, child abuse, and murder charges that you're going to be presented with, is how did she die? What happened to her? What is proven beyond and to the exclusion of every reasonable doubt? Not just some, but every single one. And those questions were never answered. That evidence was never presented to you. In fact, there was a great deal of things that you were probably looking for and never received. Now, I'd like to explain to you that this is my last opportunity to speak with you individually. After I'm done, Mr. Mason will then stand up and cover the jury instructions and the law. And then I will have one last opportunity to speak with you. But generally, this is our moment. This is our opportunity to show you and explain to you what we think the evidence showed in this case. The state, after we're done, will then be able to get up and have what's called a rebuttal argument. This is the hardest point for a defense lawyer because I can never come back up and respond. And the reason it's done that way is because the state has the burden of proof here. So they get that last opportunity. They have the burden of beyond and to the exclusion of every reasonable doubt, which is the highest standard in American jurisprudence. It is the highest standard that must be met. So that is why they're afforded that opportunity to have the last word. It wasn't because we tossed a coin and they won. It's because it is their burden. And you'll recall when I told you in the very beginning, when we did the jury selection, and I had the unique opportunity to speak to each and every one of you individually, I told you it's not a two-sided affair. The state has the only burden here. And while the defense did put on a case and did put on evidence and testimony, it was never required to do so. We could have sat back, not questioned not one single witness, and did absolutely nothing throughout the course of this trial. And it still would have been the burden of the state of Florida to prove every element in every charge. And you'll recall when we talked at jury selection, we talked about elements and what they mean. And Mr. Mason is going to come up and give you a little more detail as to that. But that's the same burden, beyond and to the exclusion of every reasonable doubt. And it's done that for obvious reasons. We're here for a serious matter. You all left your homes to come and resolve a serious question of fact. And if you were not given the facts you need, your guidance will be the law. The law will guide you as to what your decision and what is a legal and just decision. Judge Perry will tell you that what is important is that you follow the law. We all have laws. We all have lived by these laws for many years, and no one has the right when deliberating to base their decision on emotion. Now, what I'd like to talk to you about and how I've broken down my final remarks to you are, I'm going to start with my biggest fear. I'm going to tell you right up front what I fear may happen in this case. And I want to talk to you about it and explain why I feel that way. I want to then outline the state's case. I want to talk about it piece by piece. And my presentation will be a little bit longer than Mr. Ashton's because I want to actually show you what I think the evidence showed. Now, you're going to have to rely on your recollection of how the evidence was presented. It's true. What we say is not evidence, but it's a guide for you to look at the evidence from a certain angle and a certain perspective. There were lots of delays in this trial. There were times we went at sidebar. There were times objections were raised. What you have to look at the evidence by is by what actually was testified to. And sometimes it came out a little odd. Sometimes it didn't come out with as much cohesiveness. And the presentation wasn't as fine as both sides would have liked it to have been. I certainly know that was the case with us. But the problem is this is the purpose of us coming up here and talking to you, to show you we think this has a connection to this. We want you to pay attention to this fact because of this and what came on later on, and try and tie it and piece it together for you so you can look back and say, yes, I remember that happening, but when it happened, I wasn't so sure what it meant. But now that you explain it, I understand what you're trying to say and what your point is. So that's the purpose of what I'm going to do when I talk about the state's case. And then I want to talk about the defense's case, the presentation that we put on, even though we weren't required to do anything, even though the law says that the defense has no burden and does not have to prove anything. Then after that, as I mentioned, Mr. Mason will get up and explain what the charges are and explain what must be proven, and also explain the judge's instructions to you and how they apply to the defense's case and how they apply to the state's case, to try and give you an understanding. We realize while you're all very educated people, you're not skilled in the area of the law. So this is something that we'll want to use to assist you in that regard. And then finally, I will have my last remarks that I think are something that are points that I think you should also consider before we sit down. And as I mentioned, it is going to be the toughest time when midstream verdict goes up, but you have to understand the reason why. Now, let me start with my biggest fear. And that is that this case deals with so much emotion. I know that there were times where every single person in here felt something deep down inside. The law gives us a guidance as to what we should do when it comes to emotion. And that is your rules of deliberation. What the law is that this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. And that's because, obviously, we want you to base your verdict on the evidence, not on emotion. And while there were times where emotion was directly pointed at you, where things were done to draw into your emotion, to get you angry at someone, to get you to discriminate against someone because they didn't act the way they should have acted. They should have acted. They didn't conform with what we think is right or normal. They're different. And that is not what the law is. The law says you must base your verdict on the evidence, not on emotion. And it's my biggest fear because it's such a difficult thing for you to push aside. Caylee Anthony was a beautiful, sweet, innocent child who died far too soon. There's no doubt about it, and that is not disputed by anyone. But to parade her up here to invoke your emotion would be improper. It's improper under the law, and it's improper as to the rules of your deliberation. And I submit to you that that is the strategy and the way the state presented this case. They started with, well, let me just start with Mr. Ashton's remarks to you today because they're the most recent in your mind. Mr. Ashton started out showing you a video of little Caylee, started talking to you about parenting, started talking to you about what a mother should and should not do. He went on for a great length of time talking about this beautiful child, not on his evidence, not on the evidence that was presented before you. It was to set up the emotion for what was to come. And that is exactly how this case was presented. They didn't come right out the gate and show you the evidence. They gave you 2 weeks of testimony that was completely irrelevant and served only one purpose. And that was to paint Caylee Anthony as a slut, as a party girl, as a girl who lies, and has absolutely nothing to do with how Caylee died. And you would dishonor the law and even Caylee's memory if you were to base your decision on anything but the evidence. And to use emotion to get you angry is improper. And here is the proof. And Judge Perry will read that to you. It is rule number 3, but I ask that you make this rule number 1. The state came out and paraded all of these people. But what was unique is throughout that process, everyone kept coming back with the same thing. Caylee was a good mother. Caylee loved Caylee. And what was funny is I wanted you all to see something, and you may have wondered why I asked certain questions. I asked many of the questions as to how did Caylee react to Caylee, because I thought it was important that you understand that, of course, a child cannot fake this. A child cannot fake love. A child knows when it loves someone, it behaves a certain way. And I brought those questions out, and I asked them from both angles. How did Caylee treat Caylee, and vice versa? And what this did was, it wasn't to appeal to your emotion. It was specifically directed at the child abuse charges. We were here for a couple of months, at least 6 weeks, as Mr. Ashton pointed out. But you didn't hear one single instance having anything to do with child abuse. Not one. And this prosecution was geared in such a manner that it was deliberate, it was methodical, it was thorough, and it was detailed. You saw during those 30 days every movement of where Caylee went and every single thing she did. And if there was one instance of child abuse, you would have heard it. You would have seen it. You would have been able to, it would have become clear. So if you look at these child abuse charges, ask yourself, when did someone get on this stand and tell me or demonstrate in any way that Caylee was abused? Child abuse cases are sad, and they're one of the most horrible crimes imaginable. But one thing's for certain, if there's an abused child, people know it. People see bruises. People see different things about that child. They will see there will be broken bones at times. There will be different instances. But there was nothing other than the fact that this child was loved and well taken care of. And from one moment to the next, something happened. Something changed. Something changed that will forever change the life of Casey Anthony, and something forever changed that ended the life of Caylee Anthony. It was sudden and immediate, not deliberate, not repeated, not premeditated, but something from one moment to the next. You have to rely on the evidence. What came forward? What was put before you? I agree with one statement that Mr. Ashton said, is you can't speculate. Don't speculate. Don't guess. It has to be proven to you beyond and to the exclusion of every reasonable doubt. If you don't know what happened, it wasn't proven. We don't want you to tell us what you think happened. We want you to tell us what was proven happened. And that's the difference here. Because you know what? We can go on and speculate all day long as to the different theories that were posed before you, as to the different possibilities. But the truth of the matter is it must be what was proven. There are no mysteries to solve here. There should be no mystery before you right now. If you have questions, then it was not proven. And that's as simple as it goes. It's as simple as it gets, because that is exactly what is done. Now, you have seen this checkbook prosecution where they spared no expense, utilized the finest crime labs in the country, the FBI laboratory, but yet with all of the resources, and used not only established areas of forensic science, but created new ones. Ones that were never testified before in front of a jury. You are the first jury to ever hear some of the evidence in this case, this type of evidence, air evidence, the very first. You're the first ones in the state of Florida ever hear hair banding evidence. You're the first ones in the state of Florida ever hear a trainer testify about his dog. You're the first one to ever hear any of these types of evidence. And that's what I told you from the very beginning, that this prosecution would raise to the level of desperation to make up for their lack of evidence. Now, back to what I was saying with their initial setup, the way the case was presented, the first couple of weeks. You see, the strategy behind that is if you hate her, if you think she's a lying, no good slut, then you'll start to look at this evidence in a different light. You'll start to, oh, wait a minute. Maybe I'm seeing something that's not there. And start to actually discriminate against her rather than give her the standard that is afforded to each and every citizen in our country. And that is that the state, that the government come in here and prove their case beyond and to the exclusion of every reasonable doubt. But you can get away with that if we can get a jury to hate her. We can get away with that if we paint her in a certain light that has nothing to do with the evidence and more to do with who she is. I told you at the very beginning of this case that this was an accident that snowballed out of control. And while it was a very common accident, what made it unique, what made it different, is not what happened, but who it happened to. And you all sat here and saw some bizarre things throughout the course of this trial. Bizarre things that have been going on long before Caylee was ever born, and throughout her early life. You saw all of these things. This is not stuff that is new. There's something wrong here, something not right. And that's what makes this death behavior relevant. It explains it. But at the end of the day, it is irrelevant to the number one question that you all came here to answer. How did she die? And I will jump and piggyback off of what Mr. Ashton said and ask you not to speculate as to that fact. Now, I want to start with the car, okay? And what's unique about the car is, again, what I told you at the very beginning. The car does not shed any light on how Caylee died, period. And I told you all, it will double the length of this trial, if not triple. And I think I showed you that that ended up being true. All of the discussion that came around with being irrelevant evidence ended up being posed as to the car. Now, and I say that for this, because what the car does is it tells you how Caylee may or may not have been transported. It doesn't explain how she died in any way, shape, or form. And you may be asking, well, why did you spend so much time fighting it? Well, we weren't about to allow the state to put a square peg through a round hole. And that's that. Because there are just as many questions as there are answers relating to the car. Who had possession of it all the time? Did George Anthony have access to it? And there was testimony that came out. And was there, in fact, actually a body in the back of the car? But at the end of the day, we come back to, does it tell us how she died? No. We all know Casey acted inappropriately and made some mistakes and bad decisions. She should have called the police. She should have not attempted to block this out. She should have reported her death. There's no doubt about that. And that question was never contested. That issue was never debated. But if there are crimes associated with those acts, the state of Florida has the ability to charge her with whatever crimes they feel those acts warrant. They don't have the right to overcharge or inflate the case, to make it something that it's not, just because it's entertainment, just because everybody wants to know, just because there's some mystery. You heard tons and tons of evidence of how this case, the media, and the way it was portrayed, and the way it all came about, how it influenced people's actions, decisions, for both sides. But we can't lose focus of what actually occurred. And that's the answers that you're supposed to answer here for us during your deliberations. I want to start off with the issue of the car. Now, you'll recall I used these boards during my opening statement when I explained certain things. And I think going back to them will kind of help you with the timeline of things. You'll recall that on the 27th, you'll recall that Caylee was last seen on June 16th, according to George Anthony, the testimony of George Anthony. Now, I will remind you that the indictment reads from June 15th. Not June 16th. And that is very important for you to consider. And that raises the question is, Does even the state of Florida believe that she was last seen?
Objection. The indictment itself is not evidence. It is charged in a way that says between certain.
Sustained, let's move on.
Look at the indictment. Look at all of the instructions. Sir. You'll recall Tony Lazzaro testified that, and he was the young man that was dating Casey. And you'll recall that on the 20th of June, Casey ran out of gas. And Tony went to the apartment Tony went to help her get gas. They went to the Anthony home, and in the back of the backyard, there is the shed where they got the gas cans from. You'll recall his testimony, and his testimony was clear that when they went to pour the gas, Casey did not try to block him away. Casey did not say, "Hey, don't get near my trunk." In fact, they poured the gas in the car. They opened the trunk, and they put the gas, and she put the gas cans in the trunk of the car. She could have easily put them in the front seat. She could have done whatever she wanted. She could have told him, "Go away, I've got this." She could have never gotten assistance from Tony Lazzaro at all. If she had a body, as suggested by the state, in the trunk of the car, or if the smell had been there, this young man would have smelled it. Remember, he put up with his hand and he went like that and he said, "It's right here." You've seen pictures of the car. The gas gauge, the place where you put gas in the gas tank, is right next to the back of the car. Why didn't he smell it? What happened there? Well, there's a reason for that, and that's because the car didn't smell at that time. That's the only logical conclusion. You'll also remember a young lady by the name of Maria Kish. She was a very attractive girl with glasses, one of Tony Lazzaro's roommate's girlfriend. You may not have noticed the bombshell that hit when Mr. George asked her about ever getting in that car. He got an answer he didn't expect. And that was, "Yeah, I was in Casey's car." And was it during the time that she was living with Tony? And she answered yes. Remember, they all went to McDonald's. All four of them got in that car, and Maria and her boyfriend sat in the back seat, and they didn't smell anything. But yet, 2 years later, it still smells, and all of these people are smelling this smell. Why wouldn't it smell that bad when it was most recent? Why is it not smelling to these people? And we're going to get into who smelled what, but take that into consideration when you look at this. Then you'll recall the incident with the gas cans. That was reported missing to the police on June 24th. I labored over these gas cans throughout this trial because I think the issue is obvious. Who in the world reports gas cans missing? Who, not even in the state of Florida, how many times in the United States has someone called the police and said, "Someone stole my gas cans"? And why is that duct tape on there? And why are there so many lies surrounding that gas can and that duct tape? It's not a coincidence. If so, it would be an incredible coincidence. You couldn't have odds worse than the lottery. That's how bad it is. Then the car is towed on the 30th. You recall Mr. Simon Birch testifying that after 4 days, they sent out their notice. So what happened this entire week? Why did Mr. Anthony wait until the 15th to pick up the car? Why? Remember this fact. Mr. Birch said when George Anthony went to pick up the car, he showed up with a gas can. He knew the car was out of gas. And an important and even more important fact that you should remember is not only did he know it was out of gas, he knew that the car had been at the Amscot for 3 days. Remember that? He said, Mr. Anthony told me that it had been there for 3 days. And I asked him, would you have known it was there for 3 days? No, as tow people, we just go pick up the tow yard. We would have no idea how long a car has been at a certain place. But he told us it was there for 3 days. Well, even though Mr. Anthony heard that testimony, he got up here on the stand and he said, I called when I got to work. I found out that it was there 3 days when I got to work. And I asked him, did you call Mr. Birch to let him know that it had been there for 3 days? He said, no. So how in the world did Mr. Birch know that the car was at the Amscot for 3 days? He knew because George Anthony told him. George Anthony knew that that car was at the Amscot. He knew that that car was out of gas. And he showed up to pick up the car with his key. And when he got there, you all remember, he smelled the smell of death. He smelled the smell that you never forget. And of course, he did what every responsible parent would do, and that is nothing. Just go home and go to work. Nothing. Don't call to find out if my daughter is alive, who I have not seen since the 24th of June. I don't call to find out if my granddaughter's alive, since I haven't seen her since the 16th. He didn't do any of those things. And that's because he wanted to distance himself from this situation. And he knew. There's evidence of that. That was all presented to you. He knew something. He knew she was dead. This evidence doesn't make sense. And if the state of Florida had done as much work trying to track the comings and goings of George Anthony as they did Casey, you probably would have seen more. You'd probably have more answers, but you don't. Now, July 15th comes around. Let's take these down. Now, July 15th comes around, and as Mr. Ashton points out, all hell breaks loose. Now we take a look at who actually smelled what in the car. You have CSI Bloisey, who testified, depending on who was asking the questions, you may recall. If Miss Jane Burdick was asking him, oh, it was human decomposition. When I was questioning him, oh, it was decomposition. So he went back and forth. You may recall that time. You have Deputy Forgy and his dog, who was advised that this is the suspect's vehicle. And you may recall we did this small thing where I had each and every person who witnessed this dog inspection, and they all said there was only one car. But yet Deputy Forgy lied to you, and he told you there were two cars. If you believe him, you have to believe that Yuri Melich, Michael Vincent, and Gerardo Bloisey were lying to you. Michael Vincent, the other CSI person who says he smelled a dead body. Mr. Arpad Voss, and we'll get into him a little later. Cindy Anthony, who said that during her 911 call, but yet said so because this was her third call and she wanted the police to get there quicker. Simon Birch, who runs the police tow yard. Now, you may recall that Mr. Birch didn't make his statement until 9 days later, after it was broadcasted all over the news and in fact referenced news reports during his statements to the police. You have George Anthony, who did an incredible job of pointing out to Yuri Melich the first night upon arriving, as soon as he arrived. And of course, you have Dr. Neil Haskell, the $40,000 man, the entomologist, who explained several theories. Now let's take a look at who didn't smell what. Karen Sanchez, the manager at the Amscott tow yard, the Amscott check cashing place where the car was. You may recall she said she smelled garbage. Tony Lazaro, who went and got Casey, got the gas cans for Casey, and was actually right near the trunk on the 20th. Charity Beasley, the police officer who picked up the car and took it to the tow yard. Maria Kish, the girl I spoke about earlier, who sat in the back seat with her boyfriend, Clint House. He didn't smell it either. Sergeant Hosey. Now, he said he smelled something. He's a sergeant. There's a missing child. He's at the home. He's hearing lies. But yet, he didn't think it was sufficient to call the crime scene investigators. Why? Because the trash seemed like a plausible alternative. It was understandable, if trash is in the trunk of the car for 3 weeks, that is probably the source of the odor. Deputy Ryan Eberlin, this was the young man who handcuffed Casey. He said he didn't smell a thing. Yuri Melich, the lead detective, who, again, like Hosey, was advised by George Anthony and still did nothing. His name is escaping me. Fletcher, yes. Rendon Fletcher, a corporal who said he did not smell anything and came in and out of that garage and that the trunk was open. Adriana Acevedo, another police officer who was there, that said she did not smell anything. Now, I know you heard a lot of evidence about the smell of this car. And if you look at, once Casey is arrested, how many people you have to eliminate. He didn't do anything. Cindy's explanation of the reason why she said that, it leaves one person. And even if you look at all of these people and give them the credibility that they deserve, you still have an abundance of people who did not smell something. This is a reasonable doubt. When you have this many people who are telling you a certain thing, you have to have some doubt. This is not one individual like her boyfriend who's trying to protect her. These are a significant amount of people from various backgrounds who have no interest in helping Casey Anthony. And that's why you need to consider this. And that's why you may have a reasonable doubt as to who smelled what. Now, the state of Florida talked to you and presented to you a neighbor by the name of Brian Berner. You may recall, this is the individual. He was a heavy-set guy. He came up here and he testified about Casey borrowing a shovel. Now, if you think about Mr. Berner's testimony, you may recall that the police told him to close his eyes and try and remember the day that this all occurred. You'll recall that Mr. Berner didn't see what was done with the shovel. You'll recall that the shovel was borrowed for 45 minutes. And you'll also recall that Casey came back and she wasn't sweaty. And what the state wants you to believe is that Caylee Anthony, in broad daylight, was going to go borrow a neighbor's shovel, even though you all saw that they have 4 or 5 of them in their shed, and bury her child in the backyard. Is that reasonable? How does that even pass muster at all? Now, I think what maybe my colleague's response was, well, look at all of her actions. They're not rational. Okay, and I would agree with that. And Mr. Ashton said something very interesting. Bury her like she buried their pets. Okay, well, I will get back to that in a minute, but I'd like you to remember that. But okay, let's speculate now. That's what they're doing. They're saying, come, let's go speculate as to what happened with this shovel. You can easily speculate that Casey took that shovel and tried to open up the shed lock to get the gas cans. You can easily speculate that she was doing whatever with that shovel. But that shovel was tested. That shovel was inspected by the FBI, and we brought you the evidence forward, not the state of Florida. We had the people from the FBI who inspected the shovel, and there's absolutely no evidence, no DNA, no hairs, no soils that match the actual scene. There's no evidence of that. So let's just speculate, shall we? That's not proper. That's not the law. And that's not your job. But yet that's what they want you to do. That's what they're asking you to do. Now, you saw tons of testimony about the trash and the garbage. And I can't count how many times I brought this up to you and showed it to you and said, take a look at this. And I brought it to you because I think what's important here for you to remember is that this evidence was changed. This evidence was altered. Whatever evidence could be used to exculpate Casey was destroyed, put intentionally into a dry room. You don't know what food is in there. All you know is they want to dry it out. They want to, and you were passed a Velveeta cheese with fingerprint dust on it. You remember that? That black powder? Fingerprint dust. They want you to know who cut the cheese. But they don't want any other evidence to come out as to what was actually in the trash of that car. And Mr. Ashton can do his little show all he wants and show them the garbage and say, where's the spit in here? Well, we could see there was spit there. Where's this? Could this create any smell? Well, of course you can't find anything because it was altered. It was destroyed. And that's not what a police officer's job is to do. That's not what crime scene investigator Vincent and Bloisey should be doing. They should be preserving evidence, photographing evidence, documenting evidence, so that you can make an intelligent and just decision, so that you can have the evidence you need to carry out and answer any question as to what was in this garbage, what chemical compounds could come out of it. And they went out and did the air test 6 weeks later from this. How absurd, how outrageous, how unjust could that be? Now, one of the things that I will point out to you in much more detail is the issue with the computers. And I will get into the detail of the state's, the very heart of their premeditation, as they like to call it, having to do with what you heard and how you were misled in a certain direction. But I'm going to get back to this when we cover that evidence. But this evidence will so infect the quality of their case like a cancer that you will have no alternative than to render a verdict of not guilty. Actually, Judge, I think this would be a good stopping point.
Okay, ladies and gentlemen of the jury, we're going to recess for lunch at this time. Please remember, do not discuss this case among yourselves nor with anyone else. Any additional instructions on behalf of the state or the defense?
No, sir.
Okay, we'll be in recess. Okay, you may be seated. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys. Both sides ready to proceed?
Yes, Your Honor.
We miss you, Mr. Baez.
I wish I could say the same. I do have one issue that I'd like to bring up.
Yes, sir.
I apologize, but I continue to see Mr. Ashton's facial expressions as I'm doing my closing arguments, and I would ask that he refrain from showing gestures or something, whether he approves or disapproves of what I'm saying. I think the court's been clear about its order, and I would just ask that that stop.
With the signages, I can't see Mr. Ashton, but as I've made it quite plain and clear, we don't need any facial expressions of approving, disapproving, or anything else. Anything else?
Ready to go.
Okay, for those of you who may wonder why we took so long, remember we had to finish our charge conference, and unfortunately, the court reporter, while we were talking and munching on sandwiches during the charge conference, she was operating her steno machine. So we had to give her some time and some of the other court personnel some time to get a little something to eat. All right, both sides ready to proceed?
Yes.
Yes, sir.
And you've only used 38 minutes and 20.4 seconds of your 4 hours. So you have a long time to go, Mr. Baez.
Thank you, sir.
All right, let's return to jury. State recognized presence of jury.
Yes, Your Honor.
Defense?
Yes, sir, we do.
Okay, members of the jury, did you heed all of my previous admonitions during your lengthy lunch hour? Mr. Baez, you may continue, sir.
Thank you, Your Honor. May it please the court, my colleagues in the prosecution. Good afternoon, ladies and gentlemen. I'd like to pick up where we left off, and we were talking about the actual physical evidence, whether it is or whether it isn't. I'd like to call this next phase the state's fantasy of forensics. And I want to begin with the trunk of the car and this phantom stain that the state has alleged is on or in the trunk of that car. I'm looking. We've all seen the photograph, and I don't see anything that would remotely resemble a stain of human decomposition in the trunk of this car. Now, again, this goes back to grabbing your emotions early on and hoping you'll see something that's not there. We heard evidence that there's no blood in the trunk of that car. We heard numerous tests. We heard Gerardo Bloisy talk about how thorough he was in examining the trunk of this car. You may recall he said he hasn't had a car in his entire 30 years of experience where he has processed it more than he did this car. And you heard Heather Siebert from the FBI talk about when tissue decomposes, it still has cell material. And they could have gotten DNA if there was DNA in the trunk of this car. And they certainly took swabs. They certainly tried. They certainly did everything they possibly could to generate something to let you know and to prove to you that there was a body in the trunk of this car. The state wants to have it both ways. They want to say there's a stain when there is. Maggots, when all the maggots were in the trunk of, were in the actual trash bag. They want to give you all of this evidence to try and say and try and hope that if you stare hard enough, you'll either see a human decomposition stain or some other figment of your imagination. Of course, by this point, you're already angry. Your emotions are riled up, and you just might see, if you stare hard enough, if you stare long enough, you just might see a stain in the back of that car. Well, that's not true. That's not evidence. Evidence would have been a DNA report. Evidence would have been something similar to what we showed you. Something, as you may recall Dr. Huntington saying, not even professional cleaners could get that stain out of the trunk. This car was 10 years old, had a previous owner, went through 3 owners in this family, had numerous stains that were there long before June 16, 2008, long before. And you heard testimony about that. You heard actual evidence about those stains. And all they want to give you is stare a little harder and you just might see it. It's a phantom stain. It's there, you just can't see it. And this is the stuff you must look at. Remember when I told you, this investigation reached the level of desperation. And that's what this is. This is a clear sign of nothing but desperation. Nothing but desperation. Now, I want to remind all of you that some of these boards have writing on it. And the law basically says that you must rely on your memory of what was actually said. So I may repeat certain things on this, but I want to be clear. Rely on what you heard in the courtroom, not about what I'm reading to you. Okay? Now, you may recall we had Dr. Neil Haskell come up and testify. Dr. Haskell and Dr. Huntington are both forensic entomologists, and they both talked about the bugs in the trunk of this car. Or should I say the bugs in the trash bag? Because that's what they both basically testified to. They both testified that the Magnocelia scalarius is an insect that is just like a gnat, kind of like a fruit fly. What you see when you leave your doggy bag in your car for too long. What you see when you normally find trash. They are not exclusive to human decomposition. There were 0 early colonizers except that one blowfly leg. And you may recall even Dr. Huntington said, just last week I found a blowfly in my house, so it doesn't mean anything. And they are commonly found in garbage. And then there's this testimony about towels, the paper towels. Well, you heard Dr. Huntington say, you can't clean this up with paper towels. And you know, and you didn't hear any evidence of DNA or any blood found on those paper towels, because I guarantee you that would have been the first thing the state led with if they had. But they didn't give you any of that. Instead, they gave you more speculation upon speculation. Guess upon guess. They want you to fill in the gaps with your anger and your emotion. That's what they want. And they're hoping that if you talk about maggots, you'll think dead body. Well, You heard Dr. Huntington and Dr. Haskell talk about these insect activity. It's amazing how much information you can get. Right down to the time of death in some cases. Well, they had that opportunity on July 16th and would have answered all questions if they had taken DNA from those maggots. If a maggot is feeding on human tissue, it digests it. It can be extracted. And of course, none of that ever occurred in this case. No answers. No answers. Just more speculation and more speculation. Hardest thing in the world is to stand up here and talk about maggots in a case like this. The hardest thing to do is to question about maggots in a case like this. But it's necessary. It's a necessary fact that we have to confront to be able to expose and tell you what the actual evidence is, where the truth lies. And the truth lies that there is absolutely nothing in the trunk of that car that has anything to do with human decomposition fluid. So why? Why are these allegations being made? It's to make up for the lack of evidence, to have you guessing, to have you take that leap of faith into a place where you should not and you cannot under the law. Now, the next thing the state did is they talked to you about hair. And they had Stephen Shaw, a young man, and Karen Lowe, both from the FBI. I think it's fair to say, by looking at a lot of the testimony that came across in this case, that the FBI laboratory is probably the most advanced crime lab in the country, and that their employees are trained extremely well. That is why they are scientists as opposed to advocates. That is why you saw more FBI people testifying for the defense than you did for the state of Florida. Why is that? Why did we have to call 10 FBI lab personnel for you to hear evidence? Why? If this is a search for the truth, why is important information being withheld from you? And that's because this is about winning and nothing else. Winning a high-profile case and nothing else. It's not about a search for the truth. And that's what you should consider when you look at how some of this evidence was presented to you. Both Stephen Shaw and Karen Lowe would only go so far. They told you that the banding that's found in the hairs that looks similar to this they cannot say it came from a dead body. And the reason for this is quite simple. The reason is the science is just not far enough for them to know. And something very interesting and unique happened in this case. They conducted a study right after we took their deposition, when we went to Washington, D.C. to take their deposition. Stephen Shaw did his study on environmental effects on hair. Now, you may remember, this is only the second study that was ever done on environmental effects. The first one was done by a grad student out of John Jay College. The second one was done by Mr. Shaw after I took his deposition. Trying to validate their science is not the same as science. This is not DNA. And that's why they wouldn't get on this stand and say it came from a dead body. For no other reason. Because they know it. They know that the science is still in its ongoing phase. And they had similar effects that mimic post-mortem root banding. And what was interesting about this is, even the FBI analyst at the lab got these two wrong. So I guess it all depends on who's testifying in your case as to whether it's post-mortem root banding or not. Well, that's not science. That's not something you can rely on. And what's more important is neither one could ever testify as to how long that hair was in the trunk of that car. Could have been there for years. Could have been there for months. We don't know, and you don't know the conditions. But one thing you do know is that you're only talking about one hair. One hair. And how many times did we have to get Karen Lowe back? We had to bring her back to show you all of the examinations that she did. They took hair from the trunk. They took hair from the trash bag. They took hair from Casey's clothes. They took hair from her home. They vacuumed the trunk of the car. They went crazy trying to find more hairs so they could say, this came from a dead body. And they did find more hairs. You heard her say she tested hundreds of hairs, and only one hair showed something there that could have easily been from environmental effects. Easily. Now here's the thing. There are several things, but if neither one of them individually can actually stand on its own, you shouldn't consider it. They're hoping they throw enough against the wall and see what sticks. That's what they're doing here. Let's throw it all against the wall and see what sticks. Right down to their cause of death. 1 week it was chloroform. Today it's duct tape. Let's make up our minds and say we prove to you that this case was proven beyond and to the exclusion of every reasonable doubt. How can you say that? How? It makes no sense. Then we get to chloroform. I have to tell you, when I first heard chloroform being mentioned in this case, I thought to myself, this has to be a joke.
Sustain.
Chloroform began in this case by Dr. Arpad Bas. And that's how it all started. That's how this issue came up. And what happened was he testified that the reason they progressed was that the chloroform levels were shockingly high, unusually high. You all remember that. That was quite a moment in the courtroom where this forensic anthropologist, not a chemist, no matter how much his buddy Marcus Weiss wants him to be a chemist, he's not a chemist. I'd like to be a race car driver sometimes, and sometimes I drive pretty fast, but that doesn't make me a race car driver. Dr. Voss is not a chemist, but all the other chemists have different conclusions. We had to call the actual person who did the tests. The state didn't call Marcus Weiss because he would have come up here and he would have told you that all they did was a qualitative analysis, not a quantitative analysis. That's huge. That's huge. But what they want to do is have him testify about the levels when there are no levels. You can't determine how much is there because they didn't do that kind of test. So let's just guess. Let's rely on this guy who's selling a sniffer machine. Let's rely on him. But the very next witness from the FBI, a chemist, someone who is educated and experienced in that specific kind of test, came back and said, no, they were low levels. Very low levels, consistent with cleaning products. Now you have to remember, these instruments are so sensitive, they can take a drop of water and tell you all the chemicals that are in there. Fluoride, chloroform, any other type of chemicals that would be in a drop of water. They can certainly do it from any of these air tests. And that's exactly what they did. If you believe Arpad Bas, you have to believe Dr. Rickenbach was not telling the truth. They're completely different. Their testimony was completely opposites. They were polar opposites, both on the way they practiced their science. One is a crime lab, a forensic crime lab that has strict standards, and a research lab that does research. They're explorers. They pushed the boundaries of science. And that's what Arpad Vaz was doing here. Marcus Weiss wouldn't go so far. Although he wanted to talk about how great his buddy was, and I knew he was not going to be a friend of the defense. You saw his testimony. He wanted to be evasive. He didn't want to be straightforward. He didn't want to answer my questions so you could get the answers you need. No. All he wanted to do was talk about how great his buddy was, but one thing he wouldn't do is tell you how much chloroform was in the trunk of that car. Dr. Michael Sigmund, another individual, another chemist from the National Center of Forensic Science, testified that the main compound was gasoline. And they want to say, oh, well, you know, the liner was removed. Well, the air's the air, especially if they're going to test something 6 weeks later. The person who conducted the air test and collected the samples in this case was Michael Sigmund, who is a state expert. He was hired by the state of Florida, not by the defense. He was hired by the state. He was hired by the state. The only defense expert you heard from was Dr. Furton. But we had to call them all. We had to bring them to you because the state didn't do so. They wouldn't. Why is that? Is this a straightforward, straight-up prosecution? Are they giving you everything you need when someone's life hangs in the balance?
Objection to the violation of paragraph 5 of the court's order.
Overrule at this point.
These are things you have to consider, the lack of evidence. You have to consider all of these things and take a look at it and wonder why some of these questions weren't answered. And why were these people hidden from you? Why? Is that justice? Is that a search for the truth? Is that what a citizen deserves in our country, in our state of Florida? Is that what someone deserves when facing trial for their life? I suggest to you that it isn't. And I suggest to you that this lack of straightforwardness is unacceptable. And when the truth surfaces, it hurts a lot more than the single lie. Now, dealing with Arpad Vaz, you heard that he had a financial motive. You heard about his patent for his sniffer machine. This device that he's trying to create to sell to law enforcement agencies across the country and even across the world. He has done some research, but he's not the only one. He had a guy in Greece tell you that he agrees with him. Well, we didn't see anybody from Greece testify up here. The other individual who had done a lot of research in this area is Dr. Furton. You heard from him. And while I disagree with Mr. Ashton's characterizations of his testimony, he testified that there is no signature, there are no chemical aspects of decomposition yet. It's at its infancy stage. And this man will be much more willing to take the leap of faith because it hits his wallet. And his too. Some of his designs and some of the work he's doing is great. It's groundbreaking. It's excellent. But that doesn't make it science. That doesn't make it true. You also heard him talk about a thing called divining rods. I don't know if you remember that, but he said you can actually take a coat hanger and find a hidden grave with it. He said that. He said you can find a clandestine grave by going around with a coat hanger and that it's actual science. Well, if that were the case, what does he need a sniffer machine for? But this is the kind of nonsense, the kind of stretching of the imagination that our pod boss engages in. Maybe one day he'll be able to sell hangers and patent that idea. But this is the level of absurdity, the desperation that this case, that this prosecution will take it to. They'll take it to the next level. They'll ask you to see things that aren't there. And they'll ask you to imagine fictional science. It's a fantasy of forensics, is what it is. A forensic fantasy, and nothing more. We have the most advanced crime-fighting tools available to us anywhere in the world. And they couldn't find a single link from Casey to Caylee's death. Not a single link. But yet they want to create things for what? The cameras? Because it's a high-profile case? No, because it's about winning. Win at all costs, no matter how much it costs, no matter what it costs.
Counsel is violating paragraph 5 of the court's order regarding derogatory comments against counsel.
Sustained.
Strike argument as the jury.
Okay, let's move on.
Now I want to take you to what I think the evidence showed in this case, where it reached its most outrageous level. And that is the computer searches. The state of Florida took this approach. This gentleman, Sergeant Stenger, a police officer, did in August of 2008 using a software called net analysis. He did a report, and his report came out. And this was on the main issue in this case, the chloroform. They were looking for chloroform, and they got it. Okay? They got it. And this report comes out showing the size spot one time, one visit. But something really odd happened at trial. Sergeant Stenger didn't testify to his report. In fact, he goes to a seminar a year later and tries out this new software called Cashback. So what happens? He can't get Cashback to work. And he tells the owner of the company, a guy from Canada, hey, I can't get this thing to work. I've got this high-profile case, and I need this to work. So as you heard Mr. Bradley testify, that he stayed up 3 nights trying to get it to work. 3 nights. And finally, he got it to work. And they come back with 84 searches for chloroform. Now, what was odd, when I saw that, it was a jaw-dropping moment for me. And it was a jaw-dropping moment in this courtroom because I know I couldn't have missed that. What? And it took, and I went back and we looked back and we finally realized the net analysis report. This man not only testified falsely about what was there, he testified about somebody else's report, Kevin Stenger. And you'll remember when I asked him about this report, he said, this is not my report. And I asked him, can you testify intelligently about anything in Sergeant Stenger's report? And he said, no. He said, no. This report that's in evidence, and you'll take it back with you, States Exhibit 166, was done Friday, June 3rd, 2011. You had already been jurors in this case. And he does this report. And the state of Florida calls this man to testify after this report had been done in August 2008 with an established piece of software saying something completely different. This is fraud. This is trying to pull a fast one.
Your Honor, objection again to violation of paragraph 5 regarding
Sustained.
comments. Move to strike.
Motion to strike granted. Jury instructed to disregard last comment.
This is not true evidence. This is not true evidence. This is not the truth. A human life lies in the balance. You're being asked to make the biggest decision of your life. You're being asked to take someone's life if you feel the evidence deserves to be. And this is the type of evidence you're given. I suspect that when the prosecution gets back up, they'll ask you, or they'll tell you you should rely on the lower number. Because this is the true number. And you know this is the true number because of the progression that we showed you. This was Facebook. 84 times was MySpace. MySpace was just 2 levels up. MySpace is not even on this report. How did that get missed? And I showed you, and when I called the man who wrote the report, we called him to expose it to you, to expose the truth. Why, when the defense has no burden under the law, does the defense have to call witnesses, police officers, to testify, to tell you the truth, to bring the truth to light, so you can see and you can render a just verdict? This is outrageous. And you will see in Defense Exhibit 45 the progression of when someone typed MySpace in 84 times, 83, 82, and you see the progression. You see no such thing on this report. You don't even see MySpace. This is their premeditation. This is their murder case. And Mr. Ashton gets up here and says, we can only hope that she issued the chloroform beforehand. Hope? They weren't asking you, they're hoping they're going to get a conviction now? They're hoping that you'll buy the chloroform? They're hoping? You're not supposed to hope. You're supposed to prove cases beyond and to the exclusion of every reasonable doubt. Where do they get this stuff from? How can they ask you to do this? How can they come forward with this evidence? This junk that doesn't even work? And why wouldn't they have him do a report? He's the creator of the software. Why didn't he issue a report? Why? He's in Canada now. Nobody's going to prosecute him for perjury. This is a police officer who works here. And he didn't say a word about this report until we called him and had to show you that there are no such searches of being 84 times for chloroform. The extent of the computer is this: 3 minutes worth of time 3 months earlier that have nothing to do with this case, and everything to do with the MySpace posting. The MySpace posting of Ricardo Morales. You heard evidence, ladies and gentlemen, that Ricardo Morales posted this on his MySpace at the same exact time that he was dating Caylee Anthony. He also testified that he was dating her in March. March is the same exact month as these searches. If you don't know what chloroform is, and your boyfriend is posting things like this on his MySpace page, it beckons the curiosity of what exactly that is, especially to someone who's young. What is that? Is that true? Can that actually happen? It's not unreasonable for a young woman to decide to research something like this based on what her boyfriend is posting. And wouldn't you know, what is the first search before the very first chloroform search is? MySpace. Exactly where he posted it. my space. Now, then there comes the issue of Cindy Anthony. Well, we all knew Cindy Anthony in 2009 testified to doing these searches. We all knew that, both the state of Florida and the defense. That was something you needed to hear. And what the state of Florida decided to do is then go out and spend their entire rebuttal case to prove she's a liar. Well, I told you she was a liar the first day. I told you how this family lies. That has been clear throughout this case. Throughout this case. But there's one thing you can't deny, and that is MySpace goes right before the next Google search, how to make chloroform. This is not true. This is misleading. And Ms. Jane Burdick, when she questioned Cindy Anthony on the stand, she said 84 5 times. She kept questioning her. 84 times you searched for chlorophyll? 84 times? When this report was in existence. Why? How could she do that? How can that evidence come before you? How is that truth? That's why you have more questions than answers. That's why situations like fantasy searches, fantasy forensics, phantom stickers, phantom stains, all of this nonsense. And no real hard evidence, no DNA, no fingerprints, nothing. But she's a liar and a slut. Convict her on that. And she lied. And she didn't act the way she needs to. She made some stupid decisions, but let's make her pay with her life. That's what this case is about. An accident that snowballed out of control. And it's out of control. It's out of control right now. And it has been out of control since the moment this trial began, since the moment this case began. It's out of control. And it's true. Casey made some bad decisions and started this. But it doesn't have to be continued. It doesn't have to be presented this way. This case does not have to come out this way. The truth stops here. The truth starts here. The nonsense stops right now. It should have stopped the moment you all raised your hands and chose to be jurors in this case and took that oath. Every single thing, all of that nonsense should have stopped, but it didn't. And this is what they want you to render a verdict. This is sufficient reasonable doubt, ladies and gentlemen, for you to say, you know what? I don't trust this evidence. This is proof, conclusive proof, that I don't trust this evidence. And on something so serious, when the law says I can reject part of it or I can reject the whole thing. It's just like there's an old legal adage that says if you go to a restaurant and you buy a meal and you find a bug in your meal, you don't take the bug out and continue eating. You send it back. You send it back. Something as so serious as your health, you would never risk that with. Now those are types of situations. That's in the situation you're right here in now. A situation so serious that when you make that decision in the jury deliberation room, it is irrevocable. You can never take it back. You can never say, my God, I made a mistake. You can never say, can I change my mind? Can I take that back? No, it's done. It's done. These types of decisions of reasonable doubt, that's why we have that standard. If this were a financial sheet and you had your entire life savings and you're about to retire and you say to yourself, I'm going to invest with this man because he's given me great numbers.
Your Honor, object to golden rule argument.
Sustain. Motion to strike granted.
These types of decisions are life-changing, unchangeable decisions. And this type of evidence is reasonable doubt. That stain that never was is reasonable doubt. All of these aspects, the way this was presented to you, is all reasonable doubt. And here's the thing. If you don't know what happened, that's it. If it wasn't proven to you that it happened, that's it. It's over. It's not guilty on every count. Only the ones that were proven to you beyond and to the exclusion of every reasonable doubt come back. That's it. That's what our law is. And all the emotion and all the anger can never change that, because it works the same for John as it does for Jane, as it does for Casey. That's how we have our society. Those are the laws we have chosen to make the law equal for everyone, equal justice under the law. That's what we have. And you've got to follow it. The law is your guide here. Not myself, not Mr. Ashton, not Ms. Drain Burdick, the law. And the law will guide you, and it already has been, and will in the deliberation room, that this is what they must prove. Not anything less, because we will not accept anything less. The fantasies continue with the phantom heart sticker. Where in the world did this come from? This is outrageous. A young, very eager FBI analyst, Elizabeth Fontaine, sees something on the duct tape as she's examining it. Something in the outline of a heart appeared on the corner. Okay? That certainly deserves looking into a bit further. Well, they then recover 30 feet away. You recall Murdoch, Mr. Murdoch, who processed the scene, had his computer with the computer program, and we called him to show you how far away this was found. And this looks nothing like the stickers were found at the home. Nothing. And this child had all kinds of stickers in her house. You're not going to find a small child like that without heart-shaped stickers in their home. There were also Mickey Mouse stickers. There were also Goofy stickers, all kinds of other stickers. A scrapbook that was used by Casey to document her child's life. And they tried to sell you that this thing found in an area where trash is dumped, okay? Trash is dumped there, 30 feet away, across the street from an elementary school. How unusual, how crazy is it going to be that you're going to find a sticker attached to a cardboard, not attached to duct tape, 30 feet away? But that doesn't matter, because if you remember, the prosecutor, when they got up, their next question was, wouldn't you agree that this area was a trash dump? Playing on that anger again, playing on your emotions, trying to get you angry and say, yeah, that heart sticker was there. Well, why did they hide her from you? Why did the defense have to call Lori Gottesman? You remember, she used the VSC machine. She's a document examiner for the FBI that showed us all the different things that they do to find and uncover things with documents and things like that. And she saw no sticker or sticker fragments observed on any of the items. None. It didn't exist. It has nothing to do with this case. This has nothing to do with this case. But if you lie on your anger, if you rely on your frustration, your desire for blood, then yeah, maybe you can make this square peg fit through the round hole. Maybe if you squint your eyes hard enough, that sticker looks a little bit like one of these. This is outrageous. This is the quality of their case. This is the quality of the evidence put before you. But that's all that, these are some of the things that we were only able to uncover. if this investigation was focused, open-minded, not just arrest her within 24 hours, we'll get the evidence later. That's what happened here. She was arrested within several hours, arrested for child neglect, and they went out and got the evidence later. Okay, bring that car over here now. Forget all 7, 8 cops who were there that night. Today, it smells like a dead body. Forget everybody who saw it and smelled it, but today it smells like a dead body. Let's get rid of the trash because we don't want anybody thinking this was trash, this smell. If they're going to be this sneaky with this type of evidence, how much can you trust the rest of them?
Objection, violation of paragraph 5.
Not a violation of paragraph 5.
Sustain.
Let's stretch the truth here a bit further. How is this even presented to you? How does this even, what about all the beer bottles found next to this sticker? Why weren't they presented? What about, well, maybe we could dust those bottles for fingerprints and see who the killer was. Why not? It's just as reasonable. It's far away, but it doesn't matter. It was out there. That's the kind of evidence that you have to render your verdict on. Let's take this out. And then we come to Dr. Jan Garavaglia. The medical examiner. She told you that she did an autopsy on the remains. This child had no broken bones, no evidence of prior trauma, no evidence of trauma at all. And she sent out all of the toxicological exams that she could to try and make this case fit. They all came back negative. You heard the test for chloroform, negative. The test for Xanax, negative. All of these other drugs, negative, 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 negative. Cause of death, unknown. And that's where the science ends. That's it. And that's where we are here today. How did Caylee die? You would think that you can get a medical examiner to come and talk to you about medicine, about science. She has a little leeway with the manner of death. They want to tell you it's a homicide without telling you how. Why is it a homicide? Well, because I said so. Well, these are her 3 reasons. The injury was not reported to the authorities immediately. You don't need to be a doctor to know that. The body was hidden in a wooded area. Well, you don't need to be a medical examiner to do that either. Duct tape appeared to be applied to the lower face. Appeared. You don't need to be a doctor to know that, to render that opinion either. These are all opinions that have nothing to do with what this woman was trained to do. Nothing. Absolutely nothing. A person on the street riding a bicycle could give you these same facts and say the same thing. This is not science. The science she used was straight up, they can't establish the cause of death. And everything else came back negative. Everything they suspected, and as Mr. Ashton said, everything they hoped for was not there. And you remember, Fury Melich got up here and he testified to you, we did 3 search warrants on that house. We found no printing paper. We have found no paperwork having anything to do with chloroform. We found no receipts for purchases of chloroform. There were no purchases for chloroform found on this computer. They didn't find any chemistry kits. They didn't find any containers containing chloroform. They didn't find any ingredients making chloroform. They didn't find anything whatsoever having to do with chloroform. Nothing. But they're hoping. Let's hope. And Dr. Garavaglia gives you this. Well, if that wasn't enough, of course, you had Dr. Schultz, whose real purpose was to tell you and to get you more angry about how her remains were treated afterwards. But he did say no trauma to the bones. Mr. Fantasy Man, Dr. Warren, who for some reason showed you a video of a smiling Casey and a smiling Casey with some duct tape that he got off the internet. He Googled it, got that photo, stuck some duct tape on it on Photoshop, and there you go. There's your new murder weapon of the week. That's how she died. Well, that's not evidence. And he himself said, the only reason I suggested is that to show it could have happened. Well, she could have been shot, but they don't have a video of her getting shot, even though they could have done one. She could have died any number of ways, and they didn't show you videos of that. He was up there being an advocate, not a scientist, and showed you that video for one reason and one reason only. And you know what it is. Dr. Schultz testified to the same thing. But Dr. Schultz didn't have the same opinion as Dr. Garavaglia. Dr. Garavaglia said it was homicide. He had no opinion on either one. She jumped in because this was a high-profile case. He was the first medical examiner, board certified, fully capable of handling this case, but yet she's the big shot, and she comes back into town and takes over. And because of her relationship with the media and law enforcement. That's it. The politics at the medical examiner played out, at the medical examiner's office played out in this case, and you got to see it with these two. We presented to you, and we were fortunate enough to have one of the most experienced medical examiners in the country, Dr. Werner Spitz. And Dr. Spitz did a full autopsy. They can say all they want. And if Dr. Spitz had not found anything, that would have been a different story. But he did. He found actual physical evidence, physical proof that Caylee's remains were not found and did not decompose in the manner in which the state or Mr. Kronk tried to tell you that they were. Those photographs are not indicative of how Caylee decomposed and where she was and what position she was in. This is the physical proof. The semantics of was it dirt, was it brain matter? I think a man who has 60,000 autopsies under his belt, the man that our country turned to for the commission for President Kennedy and the Reverend Dr. Martin Luther King, that man I would tend to believe over an anthropologist. I think that's his qualifications.
Counsel expressing his personal opinion.
Rephrase it, Judge. You can look at his qualifications and decide for yourself. You can look at whether he's more qualified than Dr. Garavaglia. And it's quite obvious, he is. What Mr. Ashton tried to do when cross-examining him was not question him on his science. No, he wanted to question him on the facts. He wanted to question him on how much of the police reports he had read. Well, the police reports the police didn't do the autopsy in this case. They might have for Dr. Garavaglia, they might have influenced Dr. Garavaglia, but this is a man of science who actually did a complete autopsy to check, to see what exactly could have happened to Caylee. And he did say one other thing. He did have one very important finding. He told you that when you open up a skull, and if a person has died of suffocation, There is a discoloration in the back of the ears that was not in this case. He testified to that. And he told you that it doesn't always happen, but it certainly wasn't in this case. Well, that also eliminates one of the state's theories. It's actual physical evidence. It's not hoping. It's not guessing. And it's certainly not something Dr. Garavaglia did when she botched this autopsy. Why not open up the skull if you're trying to get to the truth? Why just look through a little hole and think that you can be able to determine what's there, when obviously there was something there that was relevant, something there that could help you, that could explain to you, this isn't the way they're saying it is. You have to ignore this completely if you buy their duct tape theory. Mr. Ashton tried to get him to talk about things outside of science. Well, explain to me how someone could put the duct tape on there. There's a million ways. It doesn't necessarily mean a person did it. You've heard people referring to this area as a swamp. You've heard the state say it was underwater. Well, water is going to move around the duct tape. You also have the issue with Mr. Kronk. Rolling, skulls dropping out of bags, they're outside of bags, inside of bags. What's going on here? You have all kinds of different things, and you also got to see the photographs of the duct tape lying flat on the ground, and then at the medical examiner's all the way there. Now, initially you might say, well, that's a leap. I can't believe that evidence would be manipulated that way. But I think we've seen through the course of this evidence that that's not so far-fetched. Is there evidence of it? No, I won't go that far. But it's certainly a possibility. And if you're going to entertain fantasy forensics and other possibilities of the state of Florida, you can certainly entertain that. But we will not ask you to do so. We think you need to rely on actual physical evidence, actual true evidence, not nonsense. Something you can see, something you can look at and know exactly what is true and what's not. Not some fantasy. Now, I'd like to talk about the defense case a bit. And the judge is going to instruct you that this is the law. I've told you, I've repeated it many times, but he will tell you that the defendant is not required to present evidence or prove anything. And that's simple. It's a constitutional guarantee afforded to every citizen, every single one of us, no matter who we are, no matter how much money we have, no matter what position we hold, we all share this inalienable right. This is a right of ours. And despite any overtures that we must do so is completely untrue. And you will have the opportunity of the law to guide you in that area. And that's what Judge Perry is going to tell you. Now, I told you in the beginning of this case that Casey reacts the way she does and lies because of the environment she was brought up in. The dysfunctional family, the secrets and the lies. And I told you about this photo. I showed it to you in opening. And you heard it testified to numerous times in this case. George says she looked this way because she was working out a lot. Cindy said the complete opposite. She was sedentary. She had even stood here and looked over at Casey, could clearly see she didn't look like this, and asked her to turn to the side. Turn to the side, I can't see. I don't think you can believe that they didn't know she was pregnant. And I don't think you can deny Lee Anthony's powerful testimony. The only member of the Anthony family that didn't get impeached in this case was Lee Anthony. And Lee Anthony said it straight. I confronted my mother about it, and she told me to let it go. Forget about it. You saw how hurt he was. The bizarreness of that entire situation you heard about. The lies that were testified to up on this witness stand by both George and Cindy Anthony are clear. They took an oath. Everyone in this courtroom, in this process, has taken an oath. My colleagues, myself, the judge, you guys, and every witness who took the stand. And any witness who gets up there and tells a lie does not have the right to violate that oath. Does not have that right. And you can reject their testimony. You can reject it all. It's like that plate of food. The state wants you and talk to you during their closing argument about the 30 days and all of the things that George and Cindy did. Well, mainly Cindy. In fact, George didn't do anything. You heard about that. But you heard of all these stories about what Cindy said. But by the end of this case, they're impeaching her. They want you to know she's a liar. But please believe what she said for us. That's what they're trying to, those are the goods that were being sold here in this trial. Believe her when it's convenient for us, but don't believe her in others. That's unacceptable. That's not truth. And that's not what you render a just verdict on. Casey has issues. And these issues were there long before Caylee was ever born and long before June 16, 2008. I want to show you the world that Caylee Anthony lived in, that you heard testimony in this case. You remember her imaginary friends. We had Zanny the nanny from 2006. She's a perfect 10. She used to date Jeffrey Hopkins. Remember how much amazement Mr. Ashton found and how she could remember these things? She has long black hair, but got it cut several times over 2 years. She has a beautiful smile, straight white teeth. She drives a Ford Focus, and her family is wealthy, and they come from New York and the Carolinas and Miami. Jeffrey Hopkins, the trust fund baby. He also appeared in 2006. He's a couple years older than Casey. He worked at Nickelodeon, and he had a child named Zach. You may recall the Anthonys invited him over for barbecues numerous times, and he never showed up. You had Zachary Hopkins, his son, who used to play with Caylee. You had Samantha Fernandez, Zanny's sister, and Gloria Fernandez, her mother. You may recall I asked how Cindy talked about her having heart issues. And then, of course, you have Juliette Lewis, who was Zanny's roommate. Now, you may recall Cindy testifying that her and Casey sat in the parking lot of Universal Studios for an hour and a half, waiting for Juliette Lewis to appear. Can you imagine an hour and a half sitting in a parking lot talking about this girl that's going to appear who never shows up? Not 10 minutes, not 20 minutes, an hour and a half. It's like going to the movies and sitting there and waiting. And she never appeared. And this has nothing to do with Caylee's death. This is something that just doesn't add up. This is something that's just not right. This is the world that Casey lived in. Juliet had a daughter named Annabelle. Cindy knew all about Annabelle, Caylee's playmate. You heard about Raquel Farrell, another roommate of Zanny's. She worked at Universal too. Eric Baker, who could have been Caylee's father, but he died in a car accident, in a motorcycle accident. And Caylee has a stepbrother somewhere in Kentucky. Her fictional bosses, Tom Manley and Thomas Frank, event coordinators at Universal Studios at Extension 104, which does not exist. Her office at Universal Studios that does not exist. Her office that she took police officers down the hallway to the left, across the street, and got there, and she couldn't go any further. It's at that point, at that moment, that the police should have seen and realized there's something wrong with this girl. This is not just someone lying to cover up a crime. We need to handle this investigation in a different manner. If you found a drunk guy on the street who just lost his job and he's staggering all over the place, you don't treat him the same way you would someone who's completely sober. You realize as a police officer, you have to take a step back and you have to be a professional police officer and deal with individuals who have issues as well as individuals that do not. This is what they do on a daily basis. And all the signs were there. Everything was there. Everything she was saying just didn't add up. And Mr. Ashton says, well, she didn't get a chance to carry this on or take off. Casey had plenty of opportunity to hop on a plane and go. She could have told George and Cindy Anthony, you will never see your granddaughter again, end of story, and been done with it. That's a lie. Those are actions consistent with guilt. Those are somebody fleeing the jurisdiction, not someone with an alibi that has an expiration date on it. People weren't going to just stop asking for Caylee. That wasn't going to happen. This world here, you wonder why this case got so crazy. And you look at the situation here, you look at the facts here, and the world that Casey lives in, and you realize that if a person lives in this kind of world, these facts make more sense. This cover-up makes more sense. These unhealthy coping skills make more sense. That's what Dr. Carrioth was telling you. If you're a healthy person and you've got a sound environment, you will be able to grieve, although everybody does it differently, you will be able to grieve and get some semblance of life. But if you have issues, if you don't have a healthy environment that you live in, it can go to all types of extremes, which would include going out dancing, which would include lying, which would include this fantasy. All Casey was doing, if you look at this situation, is continuing what she knew best, where she felt safe. Remember what Yuri Mellich said and put in his police report? She went somewhere where she felt safe. That speaks volumes. It speaks volumes in this case. I'm not proud of the way Casey behaved. I don't think anybody here can justify her actions, but they do not constitute murder. And you can take a look at this world and understand a little bit better. Understand where it all comes from. You understand the why. As opposed to the state's theory, where she's a loving, wonderful mother one day, and then I'm going to go party on a Monday afternoon. Even though there's no party or no club to go to, even though Tony Lazzaro said he liked Caylee, he enjoyed being around her, that this was her motive, that's nonsense. That's absolute nonsense. Yes, at first glance, you would say Casey's lies are nonsense. But when you look at it in this perspective, you look at it through the whole picture, you understand that it's not nonsense. It's not right. It's certainly not right by any standards, but it makes sense. It makes a lot more sense. She now wants her freedom? Is that what you do to get freedom? You kill somebody? That's outrageous. That's nonsense. Nobody's going to come looking for little Caylee? She's going to get to party every day and every night? That's nonsense. That's complete and total nonsense. She had no motive. Casey treated Caylee well. She loved that child. And not a single person, despite the thoroughness, despite using every law enforcement agency available to them, they couldn't find a single person to come in here, take that stand and say, you know what? Casey was a horrible mother. I saw Casey strike Caylee. I saw Casey do this. I saw Caylee do that. Casey do that. I said, you heard Tony, the guy who enjoyed her being around, and you heard him say something too, something else. Remember the time where he said Caylee was running to the pool and how Casey had to run and stop her? Everywhere you look at, there are signs of what actually happened to Caylee. And that was a perfect example that Caylee loved the pool. Casey was as protective as she could be. And on that occasion, Casey stopped her from drowning on that day and running into the pool. Obviously, she would have been there and could have saved her. But that's all you heard. That's all the evidence that was presented to you. That Casey was nothing but a good mother, despite their best efforts to parade as many of our friends up here and shot girls and everybody. And everybody said the same thing about Casey. She was a considerate person. She was a kind person. She treated me with respect. She cared for others. This is not consistent with a person who's a murderer. This is not consistent with a person who engages in child abuse, aggravated manslaughter. None of that makes sense. And the reason it doesn't make sense is because it's not true. The reason you don't have that evidence that they're desperately trying to find is because it's an unprovable case, because it's not true. That's why, despite all the efforts they tried, they couldn't give you the answers because they're not true. Next one. Now, I used an example during my opening statements of what I told you was going to come out in this trial, dealing with Caylee in the swimming pool. You heard, as the evidence was presented in this case, that Cindy and Caylee went swimming on June 15th, the day before, the night before, June 16th. And I told you, I don't know if Cindy's going to admit to leaving the ladder up. Well, she didn't do that. She says she took it down. But thanks to the state of Florida, they got to show us how truthful Cindy Anthony really is. How much guilt would she have knowing that it was her that left the ladder up that day? The denial that she must be in, the denial that she displayed when she testified in this case 6 months earlier, that she thought Caylee was still alive. Remember that. They had a memorial. They televised it. They held it in front of the world, and then they cremated her. And then she comes in here 2 years later and says, I think Caylee's still alive. Well, I understand why she said she took the ladder down that day. But what's important too is you remember that door. You remember this house had no safety locks, had no child safety locks, and Caylee could easily open the door. So if she can do that, if they were that neglectful in that sense, you can understand how the ladder would probably be brought down. Sometimes, sometimes not. Now, you heard Cindy say that on the 17th, of June, that she goes to work and actually tells people, someone's swimming in my pool. Well, why would she do that? That's an odd thing to tell your coworkers, isn't it? Someone's swimming in my pool. I saw the ladder up. We're always very sure. What are the coincidences that she would go in on the 17th and talk about the day Caylee dies and says, someone was in my pool yesterday? And this happened long before the police were called. This is not a fact that you can ignore. You heard both George and Cindy talk about how she could get out of the house very easily. In fact, we ended up showing you proof of it, which is in evidence. And you heard George testify that Caylee would wake her up in the morning and say, Jojo, swim, Jojo, swim. This is a child who loved the swimming pool. That door had no safety locks on it. She could get out quickly. She could get out easily. And if for some reason she wasn't being watched that day, that morning, when both Casey and George were home, something happened. Caylee's reported missing on July 15th. The very next day, within 24 hours, Cindy tells Detective Melich about the swimming pool. You remember that when I questioned Detective Melich, he said that he was getting calls during the Universal Inquisition when they were in the Universal Studios conference room with Casey. You heard the tape. And he left the room because Cindy was calling him left and right, desperately. And he spoke to Cindy, and Cindy told him about the ladder and the swimming pool. And he didn't, and the shocking thing that you may all remember is he had the opportunity to go back in there and ask Casey, we know what happened. Tell us about the swimming pool. And he never did. He never investigated this case as an accident. Never. He never pursued that. And that's why this case turned out the way it did, partially. Because law enforcement didn't want to keep their eyes open, didn't want to look at every possible alternative, didn't want to consider that there was something wrong with this girl. Instead, they had a murder case. And that was it. That was all they were interested in, was evidence of murder. There's nothing sexy about a drowning. There's nothing interesting about a drowning. And they didn't care. Now, we were able to uncover something that was highly unusual. And that was finding an actual photograph of Caylee opening that sliding glass door. Everyone has most parents have hundreds of pictures of their kids, but how rare is it that you would have one of her actually opening the door? But we found one. This child was heavily photographed. She was loved. Casey took hundreds and hundreds and hundreds of pictures of Caylee, even in mundane little moments like this. This was her precious child. There's the proof that she could easily get outside. There's the proof that she was big enough and strong enough to open the door. You can't get anything better than that, short of a video of what happened. And if that wasn't enough, we were able to find photographs of a year earlier of how easily Caylee could get up the ladder. And what's so odd about this is you can see how often she was photographed. Every little moment captured. And look at how soft Cindy is holding her or touching her. She's on her own. And look at what Caylee's doing. Caylee's diving into that water. This is what she loved to do. This is what she wanted to do all the time. And you can discount Cindy Anthony's testimony, but these photographs tell the truth. There are documented moments in time that do not lie and clearly show that there is a reasonable hypothesis of innocence. It is reasonable that if there are no child safety locks and she could get out, and you had the incident with the ladder the day before, and Cindy was swimming the night before, it is extremely reasonable that she could have drowned in the pool. And that's where the state fails. They must rebut each and every reasonable hypothesis of innocence. They cannot rebut this. They can't do it. It's impossible. They can say all they want about chloroform and duct tape and where the duct tape was or where it wasn't, whatever they want. The issue here is, how did she die? That's why, again, we're back to that one question. How did she die? Where did she die? Did they present one single piece of evidence as to where Caylee was when she passed away? Zero. When did she die? Why? Because she wanted to go party? They want to give you the who without the where, the how, or the why. It's impossible. This case, if you look at the law and you look at the facts, is relatively easy for you to decide. It's a tough decision to make because of the seriousness of it all. But factually, it all makes sense. And this is the only explanation that makes sense. And it makes sense because, as I said from the very beginning, it's not the commonality of the tragedy here. It's the uniqueness of who it happened to. And that's why we're here. Because these people are different. This girl is different. And this is why she behaved in this way. And this is really the only rational explanation of all of this madness, of all of it. And that's because this is what happened to Caylee. And the moment that the state failed to rebut this, and they did because they didn't present any evidence to rebut it, it was an impossible task. As you know, Dr. Garavaglia said, cause of death, unknown. That's it. They have the right and the ability to charge her with whatever inappropriate acts she may be guilty of, but they do not have the right to overcharge her of murder or manslaughter or aggravated child abuse when there is no such evidence of it. Improper disposal of a body, whatever they want, none of these crimes are before you. None of them, except the most serious, the ultimate penalty, all of these things. And I think you all know the reasons why. We've lost our senses here. Now, I want to talk about the duct tape now. And it's strange how you would have one piece of evidence that can tell you so much. Actually, two pieces of evidence that say so much about what may have happened here, and so many lies that surround it. Did you get a clear answer from George Anthony as to the gas cans and the duct tape? You can ask yourselves that. You can ask why he made certain statements. You recall Linda Tonelli, the woman who worked at the command center and said George used duct tape. He brought duct tape to the command center. And I'd like to re-show you this video if I can before we go any further. Gas cans and duct tape. Look at that duct tape. It's right there, almost the whole roll. And Mr. Ashton was correct when he said this is rare duct tape. This hasn't been sold since 2007 and was in very little quantities. You probably have never seen duct tape with a logo on it. It's always gray and silver. But you may recall when shortly 10 seconds after playing this video, George Anthony took the stand. And I asked him, where'd that duct tape come from? And his answer was, I don't know. There were a lot of people at the command center. Could have been anyone. He wouldn't even admit that that was his roll of duct tape. Completely denied it. He even denied the location of where this video was taken. You heard the judge enter in a stipulation into this case by both the prosecution and the defense. We all agreed it was at that location at that time manned by this person, and he got up there and said, nope, it wasn't there. It was at another place. He can't lie at all. He can't tell the truth at all. And he's confronted right there and then with this duct tape. But he wants to pass it off on somebody else. Then we had this issue with this photograph. Now, I'll bet you remember the first time I cross-examined him on this, I had some issues because it was the state's case and the photograph was not entered into evidence. The state did not use George Anthony to introduce this photograph. So when I cross-examined him, I was shut down.
Objection, Your Honor.
Sustained. Motion to strike granted. Disregard the last comment.
He was not cross-examined on this topic. But he said something very interesting. He said, "Sir, that photograph you're showing me, I was shown other photographs during my deposition that was not this gas can." You remember we got into the whole debate about the different, is it the round cylinder one? Is it the old one, the one you've had for 20 years? And then when it was our case, and the photograph was now in evidence, and I showed him his deposition transcripts, he went and looked at all the exhibits and then said, "Yeah, that's the one they showed me during my deposition." But he told you under oath that he was shown some other photograph, not this one, and played all kinds of games with this gas can. This is not a game. This is not a game at all. But yet he lied to you about this gas can. George Anthony lies when it's convenient for him. He lied to Mr. Ashton when he was taking his deposition. You may recall, give me the transcript. You may recall during Mr. Ashton's testimony, during Mr. Ashton's cross-examination, he said, "You remember we sparred during the deposition?" And I impeached him on this actual testimony, where Mr. Ashton said, "But it is, so it's your testimony now that when they took it on August 1st, that it did not have duct tape over the vent." And George said, "Didn't have any duct tape over the vent. And when it came back to me, or at least the last time I saw it, now it had duct tape on it. And I didn't put it on there. But is it your testimony here, under oath?" Mr. Ashton has to remind George Anthony, he's under oath, that you have a specific recollection that when the police officers took this from your home on August 1st, 2008, that piece of duct tape was not on the can. Please answer out loud, yes or no. It was not on the can. It was not on. Lying. Here's the photograph. August 1st, 2008. The duct tape's on there. But when he's sparring with Mr. Ashton, it's not on there. Cops must have planted it. Why is he lying about that duct tape? Why? He knows. He knows that he's the only one connected to the duct tape. He knows that he's caught on video by the media, hidden behind the donation jar, that duct tape was his. And you heard Cindy Anthony testify that George was the only one that had a roll of duct tape. And we get back to June 24th. Why is he reporting this gas can missing? Why is this gas can so important to him? The only connection, the only direct link to Caylee, to her remains, is this duct tape. Yes, you have other items, but the only one that it ultimately connects to is George. If this is their murder weapon, as they claim, they can't hide behind the duct tape. It only connects to him. Casey's in jail she's been in jail for 2 to 3 weeks before that entire roll of duct tape is photographed by the media. Look at these facts. Look at these events. The 24th, he issues a police report and reports him missing. The 15th, she's reported missing. He doesn't say a word about this alleged argument. Remember the argument over the gas cans in the trunk of the car? Here's your fucking gas cans. Well, on the 17th, a detective goes and inspects the shed. He doesn't say anything about that. Hey, by the way, I had this fight with my daughter. She wouldn't let me near the trunk of the car that smells like death. And here are the gas cans. Why don't you take them and fingerprint them? He doesn't say a word about them. It's not until near August 1st that he tells them about it, and they collect it. And they take this photograph. Then the first week of August, he's photographed by the media inadvertently, and all of the duct tape's the same. We're not talking about fantasy forensics anymore. We're talking about cold, hard evidence. Evidence that points to one person, and one person only. And he could get up here and lie all he wants and dance around the truth, but the truth is the truth. And depending on who's asking the questions, whether it's this laughing guy right here or whether it's myself.
Objection. Approach the bench.